Welcome to everyone today to the Land Division Committee meeting for January the 26th. And the first item on the agenda is approval of the minutes from December 15th, 2021 meeting. Are there any errors or omissions to be reported? I think everybody got a copy of it and have had to go through. Any questions?
Yes, Mr. Chair.
Yes?
Just a small issue, unless it's been corrected, but on page 12, item 1, there's a statement that a zoning bylaw amendment is in force and effect for the severed and. It's an incomplete sentence.
What page is that, John?
It's page 12, item 1. I believe it's 12. Is that a zoning bylaw amendment?
Be provided to the County of Elgin. That's.
Do you see it, Brian? Do you see it?
I don't see it here.
My copy shows and retained parcels.
On page 12?
Yeah.
I have that.
Page 12, item 1?
Yes.
The minutes, it's actually labeled in the top right corner, page 10 of the minutes, but it's page 12 when you're scrolling through everything.
On the screen, yeah. Sorry. Thanks, Jack.
Here, zoning is in force and effect.
And the applicant initiate and assume it's all part of.
So,
Done much, and this one was for,
This one's for Brownsville Road, Brownsville, so that's Malahide.
Excuse
Yeah,
me, could I
Malahide.
think it's because there's a capital on the word that
Yes, I see that.
and severed, and that should be a small t. I think that's
Should-
why.
And the applicant initiate and assume if required all engineering costs. Yes, that's,
Because it looks like a new sentence.
it's right there, Nancy. You see it, Brian?
yeah, I'm just quickly pulling up the notice of decision.
just want to confirm quickly against the notice of decision.
Yeah, so it should say for the severed and retained parcels that the applicant initiate and assume, if required, all engineering costs associated with the preparation of revised assessment schedule.
Okay. So that will be corrected, right?
We'll incorporate that correction.
Okay, that's been looked after, that one. Any other errors or omissions? Is that all right, John? That's the only one?
Yeah, no, thank you so much. That's the only one I picked up.
Okay,
I'll move the minutes be adopted as amended then.
moved by Jack Van Castern, seconder.
Second.
Second by John Selden. Now I'll have Julie call the vote.
Okay, Mr. Aldred,
Yes.
Mr. Andrews,
Yes.
Mr. O'Grady,
Yes.
Mr. Van Castren,
Yes.
Ms. Kennedy,
Yes,
Mr. Selden,
Yes.
and Mr. Fleck.
Yes.
Did I miss Mr. O'Grady?
Nope.
Oh, I got you.
Got me. Yep.
Okay, 7-0, the motion is carried.
Okay, any disclosure of pecuniary interest and general nature for this meeting? Signs posted on the applications?
Yes.
Yes. Yep.
Thank you. Thank you. I'll now ask Julie to look after the nomination for chairperson and co-chairperson.
Thank you, Mr. Chairman. So I'd like to open the floor for nominations for the position of chair. Are there any nominations?
Ian Fleck.
Ian Fleck.
Okay, so Mr. Fleck, do you
Yes, I
accept the nomination? Are there any other nominations for the position of chair?
I'll move nominations closed.
Thank you. Is anyone willing to move that Ian Fleck be the chair for Land Division Committee for 2022?
I'll move.
Thank you. That's moved by John Selden. Do I have a seconder?
John Andrews?
John Andrews, thank you. So we'll proceed with the recorded vote. Mr. Aldred?
Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Castren?
Yes,
Ms. Kennedy?
Abstain.
Mr. Selden? We'll circle back. Mr. Selden?
Yes.
Oh, thank you. And,
Sorry.
and Mr. Fleck?
Yes.
So 6-1, the motion is carried. I will now proceed with nominations for the position of vice chair. So are there any nominations from the floor for the position of vice chair?
Jack Van Castren?
I was gonna not, oh, sorry, go ahead.
Okay, thank you. Mr. Van Castren, do you agree to let your name stand for the position of vice chair?
okay.
Okay,
Nominate Dennis O'Grady.
I was,
Mr. O'Grady, do you agree to let your name stand for the position of vice chair?
No.
No. Are there other nominations for the position of vice chair? So can I have a mover to,
I'll move nominations closed.
thank you very much, and a mover to appoint Jack Van Castren as vice chair of Land Division Committee for 2022? Mover?
So move.
Thank you. Ms. Kennedy. Seconder?
I'll second it. John Andrews?
Seconded by Mr. Andrews. And we'll proceed with the recorded vote. Mr. Aldred?
Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Castren?
Abstain.
Ms. Kennedy? May have connection issues. Ms. Kennedy?
Yeah.
Thank you. Mr. Selden?
yes.
And
Yes. Oh.
Mr. Chairman?
Yes.
Thank you. 6-1, the motion is carried. So back to you, Mr. Chair.
Okay, thank you. Thank you to everyone. I appreciate the honor and as being the chairperson, and hope to work with all of you and we have a good year, and I know it will be. I'd now like to, any inquiries from Land Division Committee members? And I'd like to just mention that the members, please stay on after we are done call on, because we'll have a discussion with some stuff from Julie and Brian.
If I may, Mr. Chair, through you, ask Julie about the legal issue regarding E1421. Has that progressed any, or is there any updates on that situation?
It's all.
Not at this time.
Okay.
Anything else? I'd like to introduce Kevin McClure, who is with us from the city of St. Thomas and Central Elgin for looking after the planning for us and that today. Welcome,
Kevin.
Kevin.
You, Mr. Chair.
You have anything to say, Brian? You have any comments?
No, I've certainly worked with Kevin for several years now. He's extremely competent and qualified, so thank to have him here.
Okay, so at 9:20, we got about 10 minutes. So if there's any other inquiries from Land Division members?
Can we ask about the material that came in on E14, or is this not something we can discuss now?
No,
If I may, Mr. Chair?
yes.
So I believe that the item is subject to client solicitor privilege. So that would be a matter that is considered in closed session, though I will just note that we don't have an update at this time.
Thank you.
You're welcome.
Did I make a point, Mr. Chair?
Yes.
Ian,
Yes,
could I bring something up here for a second?
yes, go ahead, Doug.
I know we went over a list of things that applications and forms and stuff we wanted filled out on these applications. And going through these, it seems to me like some of them are missing some of the forms that we'd asked to be filled out. I don't know if anyone else noticed that or not, but I just noticed that on one especially.
One was, or what page was missing? Can you,
Well, let's see, for E122, there's no municipal assessment sheet in there at all. Which asks, if there's been any severances and all those things on it before, and that sheet
Okay, yes.
is not included in the package.
that's the page that tells us which, if there's any previous severances on a farm or
Yeah.
on different lots,
Yeah.
right? Okay,
And it may have all been no's, but, I felt it should be included in there because I know that's one of the things we asked for to be included.
Mr. Chairman, it's probably with all the changes in staffing and everything else, it is something that the new staff that we've got and the people who are helping us out aren't aware of some of the stuff we've had before. And I was going to bring this up a little bit later on the next one, but there's a lot of unwritten things and unwritten procedures and unwritten decisions and things like that this committee have had over the years. And with the staff changes, it's tough to keep track of all that. So perhaps it's just something that we need to sit down with the staff and start these lists. And then if we have this list, then staff can go through the checklist. I'm assuming that staff aren't aware of the checklists and the different forms that we require to be submitted. And that's one of the reasons it's there. And then more importantly, what do we do as a committee? If they're missing a sheet like this, and it's something that we've asked for and it's not there, then should we just automatically reject that? What is the power of each and every one of those forms? And if our decision is you need a form, and that is a decision that we made the last time, then the application should not be heard.
I'm going to ask the planner that's here just to touch base on some of that.
Thank you, Mr. Chair. Just with respect to the E1-2022, we did receive a revised municipal appraisal form back, on the 21st. As part of the application review process, it's been I guess, deferred to the municipal planning staff to check for completeness. So with this application in Malahide, it would have been incumbent on the planning staff of the municipality to check for completeness and report back to us as to whether or not it was complete. In this instance, as you're aware from the report, there are some other issues that we're recommending deferral for that we'll speak to at a later time. But an application in the municipal appraisal form was submitted, but it was submitted after the information was submitted from staff to Elgin County Land Division Committee with our recommendations.
Okay. Okay, Doug?
Yeah,
We
thank
will-
you for the explanation, but I guess it still goes to Dennis's point. What do we do if we get forms that are missing things? Because sometimes maybe they're missed on purpose because there's something they don't want us to know, and sometimes maybe they're missed by accident. So it does put us in a situation. What do we do?
I think we have the right to defer them.
Certainly, certainly.
And I think, Duke, as you know, we have the right to defer it if we don't feel the information is right at that time, which we have seen on some past ones when we've had to defer them because of lack of information.
Okay, no, and I guess that's up to committee's decision on those as we get them.
Yes. Duke, or Jack, you have a question?
Just further to that same subject, I would expect the protocol would be that if we're reviewing the information prior to the Wednesday meeting at some time, whether it be over the weekend or the Monday or the Tuesday, if we find any information missing, like Duke caught in this one, I did not. I would think it'd be incumbent upon each of us to reach out to the
Yes.
Secretary Treasurer to ask them if it was included
Yes.
in the package to prior to the meeting. And maybe
Yes.
there's still time to get that information so that it's available to us at this meeting. If not, then we have the power to defer because we didn't have enough information. Does that make sense?
Any comment from you, Kevin, on that?
Just thank you, Mr. Chair. Traditionally, I can't speak to other municipalities, but what we've done in the city is that prior to scheduling meetings to have applications heard, we check for completeness and then go through the process of creating the reports, and so that we're aware of when the application should be heard. So that's another option to consider, is that prior to scheduling of meetings, that the applications are deemed complete and reports are received well in advance of the scheduled meeting.
That okay, Jack?
Yep, that's fine.
Yeah, I think we'll see this once we get on a system of going again with the new staff and catch up on this. We'll see this check and we'll know what's going on. And this was a little crowded too, because most municipal offices were closed a bit at Christmas time and before. So there was a last minute, I understand, some coming in from some of the municipal offices. So, but we'll have a direct when we're back to the regular schedule.
Agreed.
Got 2 minutes. Okay, we're ready to go with application E 5021, which is an amended decision. in the matter of an application for consent pursuant to section 53(1) of the Planning Act, RSO 1990, as amended as it affects the following property. Concession 6 STR Part Lot 126 RP 11R9370 Part 6 Lot D, Municipality of Bayham. Municipal address is 9222 9228 Allward Street. The applicant proposes to sever a lot containing an existing semi-detached dwelling with a revised area of 814.8 square meters, 0.20 acres, and retain a lot with a revised area of 879.1 square meters, 0.217 acres, each proposed to be used for existing residential use, 1 unit of a semi-detached dwelling for each of the severed and retained lots. The original decision was July the 30th. The amended decision will be today if amended. Consent requested by WD Bronze Limited. Any questions on that or any comments on this one?
Thank you.
Go ahead, Kevin, please. First of all, excuse me, I should ask, do we have any agents and interested parties who wish to speak to this application?
Can you hear me?
Yes, who?
Oh, it's Bill Braun, owner of WD Bronze. Yeah, the original numbers that I ended up putting in for the severance was actually just done by myself, and when the surveyor ended up doing it, because the lines were not symmetrical, I ended up being off, and when we started to applying for the severance paperwork, we just noticed that that I was in error. So that's the reason for the amendment.
Okay, thank you. We'll now have Kevin speak to this one, please.
Yeah, thank you, Mr. Chair. As is common with severances for semi-detached units, until the final survey is done, it's not known exactly where the common wall is. So this is just reflecting that final survey.
Any questions from any of the members?
Mr. Chairman, this is, I guess, it doesn't pertain to this one per se because it's such a simple one, but we have had other cases where amended or surveys have changed. And again, it's one of those unwritten rules where if it's below a certain percentage, we allow it, or above a certain percentage, we allow it. And so I'm just wondering if we should start with jotting down things like this, that what I would like to see on a report like this is a staff report saying basically what staff have already said, that it's been reviewed by staff, it's within the allowance of what the Planning Act allows, and it's okay to proceed. Otherwise, we're left with a piece of paper, and I know we've got a verbal from staff, but a lot of those verbal comments are not included. It's always best to have a staff report describing that this is illegal, what they've done is legal, and it's within the parameters of the Planning Act. And then when it comes to the bigger ones, where there might be a few acres or several acres differential between the submitted plan and what the final surveyor actually does, then a similar thing should be done. A staff report saying this is allowable under the Planning Act, it's within the errors or whatever we want to call it. I don't want to slow stuff down, but I also prefer to have a staff report saying it's been reviewed by staff, and when a new survey comes in, it falls within the bounds of the Planning Act and severance.
Any further comment, Kevin?
Thank you, Mr. Chair. I guess unless there's specific rules within the county's official plan to deal with variation within, I guess, for severances or land division, the act itself only provides that it's up to the will of council or a committee of council to determine whether or not the application is deemed minimal and does not require further circulation and analysis, essentially. So unless there's certain provisions in to direct staff that this is an acceptable range in these circumstances, it's really left up to the will of the committee of council.
Well, then, Mr. Chair, how do we want to approach that then? Because we do have an unwritten rule, and I forget what the percentage is or the acreage is. And we've had that in the past. How do we want to treat these unwritten rules where, every time a new one comes in, there's a change in survey, it's a change in area. I don't really want to be reinventing the wheel every time a new survey comes in. It'd be nice to have a little bit of if not a policy, but a guideline and it written down, especially for, the future. There's, over the 4 years I've been, 3 years I've been on this committee, there's been quite a few of these unwritten rules. And it's just nice to have a compendium of them.
Julie, I'd like to speak to this.
Thank you, Mr. Chairman. Through you to committee members, I hear you. I hear that there are some procedures perhaps that are undocumented that the Land Division Committee members are perhaps accustomed to following. I recommend that we have those discussions about what we can do to formalize some of these unwritten procedures as part of the Land Division Committee's orientation, which is scheduled to follow today's regular meeting. So I suggest that we table that for now, and we can discuss with members what your preference is, what the process is in terms of seeking council approval for some of these unwritten procedures in order to formalize them, et cetera. So with your consent, Mr. Chair, that's my recommendation as we take this part of the discussion offline.
Take this off and we'll discuss it after the meeting. Okay, any other
That said,
questions?
Mr. Chair, I'd like to make a motion that we accept this amended decision, right?
Okay, it's been moved by Jack Van Castern. A seconder?
I'll second, Mr. Chair.
Second by John Selden. And I'll ask Julie to call the vote.
Mr. Aldred?
Doug?
You give us a thumbs up or down. Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Castren?
Yes.
Ms. Kennedy?
Rosemary?
Yes.
Thank you, Mr. Chairman.
Yes.
7-1, the motion is carried.
Yes.
7. Did you say 7-1, Julie?
Oh, sorry, 7-0, the motion is carried.
There you go.
My apologies.
Okay, the decision rendered today for this application will be circulated within 15 days after the notice. There's a 20-day appeal period from the giving of the notice of decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. Thank you very much. Got 1 minute. We now have application number E1-22, lots 105 to 110, Township of Malahide, municipal address 11789 Superior Street. Take notice an application has been made by Wendy D'Angelo, 11789 Superior Street, Springfield, for consent pursuant to Section 53 of the Planning Act 1990, as amended, to sever lands municipally known as 11789 Superior Street, Township of Malahide. The applicants propose to sever a parcel with a frontage of 60.38 meters, 198.10 feet, along Superior Street by a depth of 24.14 meters, 79.20 feet, and an area of 0.14 hectares, 0.35 acres for future residential use. The applicants are retaining 0.13 hectares, 0.32 acres, proposed to remain in residential use. Do we have any applicants or agents and interested parties who wish to speak to this application?
Mr. Chair, it's Matt Campbell from Zolinka Priamo here on behalf of the applicant.
Thank you, Matt. I'll now ask Kevin to speak to this, please.
Thank you, Mr. Chair. As has been, I could describe, the applicant's looking to sever off the property to two parcels through the public and agency comments. There were no comments received at the time of submission of the application by the Township of Malahide. However, we did receive some comments after the report was submitted. They were generally in support of the application, did provide some conditions. However, as is noted in the staff report for the Division Committee, through staff's review, it was recognized that or acknowledged that the parcel of land itself is comprised of full lots in a registered plan of subdivision, being lots 105 to 110. At the moment, we're currently uncertain as to whether or not they're legally conveyable parcels of land. So based on that, typically what we would request is that a legal opinion letter to determine the status of what those lots are. The reason is that if they're separately conveyable lots, then the consent granting process would not necessarily be the appropriate process at this time. The lots would need to be deemed in order to be not lots as part of the land plan of subdivision, and then they could then be severed appropriately. So at this point, staff has reached out to the applicant's agent, Mr. Campbell. He is aware of the concern, and as far as I'm aware, they're in the process of going through speaking to a lawyer and getting that opinion letter. I have spoken to the Township of Malahide planner too, and they're aware of the concerns that were raised and are amenable to that deferral recommendation as well.
Okay, any comments, Mr. Campbell?
Mr. Chairman, just a quick note. When you're looking at this stuff, looking at the survey that was submitted to us in the preliminary agenda, it looks to be only a 1.2 meter distance between the driveway, garage, and the property boundary. So maybe you could look at that and see if there's going to need to be a minor variance or something on that.
Go ahead, Kevin.
Yes, thank you, Mr. Chair. In my conversations with Adam Bettridge at the Township of Malahide, they did recognize that as part of any sort of conditions, they would need to address the accessory structure that's currently that's shown on the severed parcel of land. How they would address that through minor variance, I believe, was their preferred approach. But they, as part of any conditions that moving forward, if this is found to be the appropriate mechanism, that the accessory structure would need to be addressed through a Planning Act application.
Thank you.
Any comments from Mr. Campbell, the agent?
Thank you, Mr. Chair. As Kevin mentioned, we are aware of the legal issue with these lots potentially being in a registered plan of subdivision. So we have engaged a lawyer to provide an opinion letter on if these lots are indeed a registered plan of subdivision. If they are, then as Mr. McClure mentioned, that we have an avenue to deem them not to be a registered plan of subdivision, and then the consent application that is before you today would essentially come back to the Land Division Committee after that deeming bylaw is passed. So we're currently working on that. It's a bit of a unique situation and highly technical. So we'll get that worked out. To the point about the minor variance, when we originally looked at this application, we flagged that as something that we would likely anticipate here. In conversations with the municipality, they were of the opinion that they did not want to go through a minor variance process for this, but rather would deal with the accessory structure through a development agreement that would get registered on title of the property. In essence, they found it a little cumbersome to go through the Planning Act requirement to allow an accessory structure on a lot with no primary dwelling. And if that was legalized through a minor variance, that would essentially legalize that in perpetuity and would not recognize the need for any primary dwelling within any specific time frame. So in consultation with the municipality, it's understood that there will be a development agreement that will be entered into as a condition of severance, and that's noted on the draft conditions that were provided. The specifics of that development agreement have not been provided to us, but what I understand is that there will be a specific time frame in which construction of the new dwelling must begin, and there may be securities associated with that development agreement as well. Say, for instance, a set amount of money that would be posted, and if the dwelling was not constructed within a set amount of time, the municipality may retain those securities. In conversation with the applicants, I'm not concerned that they will not proceed with this. They very much want to proceed with a new dwelling. And just for the committee's consideration, Wendy D'Angelo is the mother here, and the son, Joe, intends to purchase the severed lands and construct a dwelling for his family there.
Thank you very much.
Thank you. I just wanted to add, we're in the committee's hands here. I do just have a question. If we are able to resolve these legal issues quickly, what would be the deadline in order to get on to the next Land Division Committee meeting?
Brian, I'll turn that over to Brian, please.
Sorry, bear with me 1 second.
Yes. You have come.
The deadline for the next available meeting would actually be today. That being next available meeting would be March 23rd. If that isn't received today, then the meeting thereafter, April 27th, with a deadline of March 2nd, would be the next available meeting.
Did you understand that, Mr. Campbell? March?
Yes, I did. Thanks, Brian.
Okay, thank you. I have one. Kevin has one more comment.
I guess, thank you, Mr. Chair. I guess my only comment to Mr. Campbell would be that based on whether or not a deeming bylaw is required, I would suggest that the applicant reach out to the Township of Malahide as to their process for and timing for passing of the deeming bylaw, because it has its own legislative timeframes for passing. So that may inform what meeting the deferred application would need to be on for the Elgin County Land Division Committee.
So any further question, or do we have a motion to defer?
I'll make a motion to defer.
Moved by Rosemary.
I'll second it, John Andrews.
Seconded by John Andrews.
Mr. Aldred?
Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Kasteren?
Yes,
Ms. Kennedy?
Yes.
Mr. Selden?
Yes,
Mr. Chairman?
Yes.
7-0, the motion is carried.
Okay. Our next application is E2-22. And application for number E2-22, parcel lot 9 and 12, Town of Aylmer, municipal address 62 Victoria Street North. Take notice that, excuse me, an application was made by Kurt and Nicole Benat Smith, 62 Victoria Street North, Aylmer, Ontario. Consent pursuant to section 53 of the Planning Act 1990 as amended to sever lands municipally known as 62 Victoria Street North, Town of Aylmer. The applicants propose to sever a parcel with a frontage of 18 meters, 59.06 feet along Victoria Street by a depth of 20.3 meters, 66.60 feet, and an area of 0.036 hectares, 0.09 acres for future residential use. The applicants are retaining 0.045 hectares, 0.11 acres, proposed to remain in residential use. Do we have any applicants or agents and interested parties who wish to speak to this application? I'll ask Kevin to speak to this, please.
Thank you, Mr. Chair. As has been already described, the proposed application is to sever off a parcel for future residential use. Through the public agency comments, Town of Aylmer did provide comment that staff has reviewed the application against the applicable official plan policies and the town's zoning bylaw. Based on its review, it is recommended that council offer support for the application to Land Division Committee, subject to the committee standard conditions, and in addition to the following recommended conditions of approval. One of those being a minor variance is approved, just given the deficiency in some of the zoning. County engineering provided that the property is not located on a county road, and the Catfish Creek Conservation Authority provided that they have no concerns with the above noted application. So through the review, the staff report recommends that the application for consent is consistent with both the 2020 provincial policy statement and complies with the County of Elgin official plan regarding lot creation and settlement areas. As such, planning staff is of the opinion that the application is acceptable from a planning perspective and recommends approval subject to the following conditions. 1, that a digital copy of the draft and final deposit reference plan be provided to the County of Elgin. 2, solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. 3, municipal addressing to be provided to the county, Elgin County, from the local municipality prior to final approval to the satisfaction of the Elgin County planning. Additionally, it is recommended that the following conditions from the Town of Aylmer be included as conditions for consent. 1, that the applicants initiate and assume all planning costs associated with the required application for minor variance, with such costs to be paid in full to the Town of Aylmer, and that the required process be successfully completed prior to the conditions being deemed fulfilled. 2, applicants provide confirmation of the location of any existing overhead or underground services installed to the lot to be retained. Services cannot traverse the adjoining lots, and any conflicts must be redirected at the cost of the applicants to the satisfaction of the Town of Aylmer. 3, that the lot to be severed be individually connected to municipal water supply and sanitary sewer, with all costs, including applicable fees and charges, to be borne by the applicants to the satisfaction of the Town of Aylmer. 4, that the draft reference plan illustrating the lot to be severed be prepared by an Ontario land surveyor for the purposes of facilitating the transaction of application for consent E2-22, and that this plan be approved by the Town of Aylmer prior to being deposited at the land registry office. 5, that municipal addressing be assigned to the lot to be severed by the Town of Aylmer, and that the confirmation of municipal addressing be provided to the Elgin County. 6, that the electronic version of the reference plan be submitted to the satisfaction of the Town of Aylmer. 7, that the Town of Aylmer advise the Secretary Treasurer of the Land Division Committee that all requirements of the Town of Aylmer have been complied with.
Any comments from any member of the committee? No comments from any member of the committee? Do we have a mover and a seconder?
I'll move that it be accepted.
Moved by
Meets
Jack
all the conditions.
with all conditions. Yeah. Jack, seconder?
I'll second Aldred.
Well, if there's no further questions, we'll call the vote.
Mr. Aldred?
Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Kasteren?
Yes,
Ms. Kennedy?
Yes.
Mr. Selden?
John?
Thank you. Mr. Chairman?
Yes.
7-0, the motion is carried.
The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. Next application is E3-22. Lot 9, Concession 3, Township of Southwold, municipal address is 35229 3rd line. Take notice that an application has been made by Pioneer Hay Sales Limited, 29013 Pioneer Line, Dutton, Ontario, for consent pursuant to Section 53 of the Planning Act, 1990, as amended, to sever lands municipally known as 35229 3rd line, Township of Southwold. The applicants propose to sever a parcel with a frontage of 57 meters, 187 feet along 3rd line by a depth of 398 meters, 1,305.77 feet, and an area of 2.6 hectares, 6.42 acres, containing a residence and 4 additional buildings for residential use. The applicants are retaining 34.6 hectares, 85.5 acres, proposed to remain in agricultural use. Do we have any applicants or agents and interested parties who wish to speak to this application? Please introduce themselves to the committee.
Yes, thank you, Mr. Chair. Jordan Folkens from BM Ross and Associates, and we're the planning consultant for the owner on this application.
Okay, thank you very much. I'll now ask Kevin to go through the application.
Thank you, Mr. Chair. As has been discussed, this is an application for surplus farm severance. Through the agency comment circulations, the Township of Southwold did provide the following recommendation: that Council of the Township of Southwold receive report PLA 2022-01 regarding consent application E3-22, comment to the County of Elgin, and that Council recommends refusal to the Land Division Committee of the County of Elgin for application E3-22 as presented, and further that Council recommends approval of a revised application with a maximum lot size of 3 acres for the severed parcel subject to the lower tier municipal conditions and Appendix 2 of report PLA 2022-01. I'll get more on that in a second. County engineering did provide that the owner dedicate lands along the frontage of the severed and retained lot parcel up to 15 meters from the center line of construction of 3rd line County Road 18 to the County of Elgin for the purposes of road widening if the right of way is not already to that width, to the satisfaction of the county engineer. All costs to be borne by the owner. Further, that if necessary, an entrance permit be obtained from Elgin County for a new entrance to be severed and or retained parcels. All costs associated with this shall be borne by the owner. And then the Lower Thames Conservation Authority provided that no objections to the property in question is subject to the authority's regulations. While there are recommendations and conditions within the report, or at the end of the report, a letter was submitted recommending deferral on the 17th. It goes back to the Township of Southwold's recommendations that the application as presented be refused, and that they recommend approval of a revised application with a maximum lot size of 3 acres. The application as presented has a lot size of 6.52 acres, which is requiring the applicant to amend its application and provide a survey to address that reduction in size. So that's what the applicant is currently requesting a deferral for, to work through those details. I guess I'm at the will of the committee of whether or not they would like me to continue on with the conditions that have been presented as part of this application and report, or whether or not they wish to go forward with the deferral as requested by the applicant at this time.
What is the wish of the committee?
Vote on the deferral.
Any other comments from any members?
I agree with John Sullivan that we need to vote on the deferral of the application as presented.
And you don't want, go ahead, John. Do you have something to say, John Andrews?
No, I agree with the deferral. Sorry.
Okay, no other comments from any committee members?
Mr. Chairman, Dennis here. What are we deferring? Are we deferring that we, to council's recommendation that it stay at 3 acres and that we are expecting a report to come back to us showing the 3 acres? Is that what we're requesting?
Go ahead, Dennis.
So if I may, the report that was submitted by the Township of Southwold generally was in support of the surplus farm severance, save and except for the actual size. So to address some of the concerns that were raised by township staff, that's where the applicant is needing to go back to actually prepare a revised application and survey in order to address those revisions. Or, sorry, to address that request.
Yes.
So,
Sorry, yeah, Mr. Chair, I think if we go back to the basics, the mandate of our committee is to approve or deny. However, if the opportunity is there for the applicant to request a deferral, then we have that option, right? So that the applicant doesn't have to start the whole process of application yet again. So based on the information provided in Kevin's report here and the written submissions, I feel that we have no choice but to deny the application as presented. Therefore, I think it's up to the committee to defer, allow a deferral, and have the revised application come back to us at a later date. That's how I see it.
I agree.
Rest of the committee members agree?
Mr. Chairman, again, I've got a couple of questions here. 3 acres, we have turned down many others in the past that are even 3 acres in size. Why is this one different? Why are we, is there, and I understand it's a long laneway and all of that. I understand there's multiple buildings. But we've dealt with where we've requested barns and buildings to be torn down in the past to maintain agricultural land. So yes, it's a reduction from 6 acres to 3. But we've had people come to this committee with 3 acres in the past, and we've asked them to reduce it below 3 acres. So what's going on with this parcel of land where we're giving them 3 acres, but we wouldn't allow others to have 3 acres? Is there that much unusable land here with a long laneway that we have no other choice but say 3 acres is the absolute minimum? Or the absolute maximum of land that could be kept?
I'll ask Dennis to speak to that and then we'll.
Kevin?
Perhaps we'll let Jordan speak to it.
Okay.
Yeah.
The agent could speak to this, please.
Yes, thank you, Mr. Chair. And yeah, I'll address that. It was in the plan report that we submitted with the application as well. But yeah, the primary factor is that the house or the dwelling is located further than 300 meters from the street. So that's really the major factor. The other one is that we did an analysis of the area, and yes, 3 acres is larger than the 1.48 allowed by the current zoning, but it is very much consistent with other surplus farm dwelling severances that have been granted in Southwold in the past, and it is consistent with other non-farm lots in the surrounding area. So there will be no actual agricultural land that's currently cultivated taken out of production. All these areas are, I believe, manicured, landscaped, have hedgerows and whatnot. And actually, that's what the major change in this would be. Since it's so far back, the original proposal would have been around the hedgerow. This will be narrowed, so the agricultural retained parcel will remain by the hedgerow. And it'd be basically follow the existing laneway. Then it would expand, and the areas around the existing accessory buildings would also be part of the retained lands. And conceptually, we have a proposal that would be less than 3 acres. That would meet Southwold's request for under 3 acres. I believe that would be more appropriate.
Any comment to that?
I don't have any
Okay.
further comment to that at this time.
Okay, Jack, yes?
I'd like to maybe comment on further to Dennis's question or comments. Just the point that a deferral will provide the opportunity for a revised application to come before this committee, right? It does not mean, Dennis, that that application will automatically be approved. It will still have to be assessed on that application's merits and the proposal before us at that time, right? I don't think a deferral in this case is just an automatic approval of a revised application later.
Kevin, you speak to that, please.
Thank you, Mr. Chair. That is correct. It is simply deferring a decision until a later date. At that time, once the applicant's agent has prepared a survey outlining exactly what has been proposed to be as part of those severed lands, the committee, the municipality, and the Elgin County land staff would be able to provide a report back as to whether or not that would be supported as a follow-up report.
Okay,
Yeah, I think that if we're deferring it and asking for a brand new survey on 3 acres, as a committee, I think we'd be hard pressed to make a decision, say, no, go back and redo the whole survey again to something under 3 acres. I think that if we defer this to 3 acres, I, for one, cannot support anything less than that. I'm not going to ask the landowner to go back and redo another survey. That's not going to happen with my vote.
Jack?
I don't think the decision to defer will specify 3 acres. So I think there are some other issues with this property with the number of outbuildings shown on the maps. And as per your point, Dennis, in the past, there have been other properties come forth where the local municipality said, now some of those outbuildings have to be torn down if they're not suitable for their zoning or their zoning bylaws or their official plan either, right? So all I'm saying is a move to defer this application as it's presented does not in any way bind us to automatically approve a revised application coming forward. That's all I'm saying.
Okay, thanks. And Kevin has one more comment.
Thank you, Mr. Chair. As was submitted to, I guess, the county with respect to the request for deferral, the request specifically states that we request that this application be deferred to a future meeting in order to address concerns that were brought to our attention from the Township of Southwold. I would, I guess, argue as the applicant's agent is in attendance today and has heard some of the concerns also raised by the committee, that they may wish to take some of those comments into consideration with respect to any revised drawings or plans that they present at a future meeting if the committee so wishes to have this application deferred and heard at a later date.
Agree.
Agree? So Jack moved it. Is that right, Jack?
I move for deferral of this application, yes.
Seconder?
John Andrews.
John Andrews. I'll ask Julie to call the vote now.
Mr. Aldred?
Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yep.
Mr. Van Kasteren?
Yes.
Ms. Kennedy?
Yes.
Mr. Selden?
Yes.
Mr. Chairman?
Yes.
7-0, the motion is carried.
Okay, thank you very much. We look forward to hearing from you again. Application is E422 and it was for 10 o'clock, so we're all right to proceed. Application E4-22, part of lot 13, Municipality of Central Elgin, address 442C West Edith Cavell Boulevard. Take notice that an application has been made by Charles Wicken, Karen D. Shaw, and Frederick D. Shaw of 1228 Eagle Trace Drive, London, Ontario, for consent pursuant to Section 53 of the Planning Act 1990, as amended, to sever lands municipally known as 442C West Edith Cavell Boulevard, Municipality of Central Elgin. The applicant proposed to sever a parcel with a frontage of 7 meters, 23 feet along West Edith Cavell Boulevard by a depth of 10 meters, 35 feet, and an area of 0.007 hectares, 0.017 or 0.017 acres to be conveyed to the adjacent property. The applicants are retaining 0.04 hectares, 0.10 acres proposed to remain in residential use. Do we have any agents or applicants and interested
Yes,
parties?
Mr. Chair, it's Mark Coombs here as agent for the applicants.
Okay, thank you very much. We'll now have Kevin McClure speak to this as the planning department.
Thank you, Mr. Chair. As has been noted, this is a severance. Essentially, it's a lot addition to deal with, by way of background, the existing cottage that it was on this parcel of land was damaged through an accident. As part of the reconstruction process for this cottage, or a request to reconstruct, it was noted that the current location of the cottage across property boundary lines, the applicant owns both parcels of land, and this is merely to adjust the property boundaries to allow for the reconstruction of the existing cottage on the parcel of land. So the municipality of Central Elgin, their comments that were provided prior to their meeting on Monday, 2 days ago. But as per the report, at the time of the writing of this report, no comments were received from the municipality of Central Elgin, other than planning staff did have available the draft planning report to be presented to council at its meeting on the January 24th meeting. Recommended that conditions have been included at the end of this report and can be confirmed by the planning staff at the committee's January 26th meeting. I was at that meeting on Monday, and the recommendations were approved by council at that meeting, save and except there is one additional condition that I will get into in a moment. County engineering, there's no comments provided, as it was on the county road. And then the Kettle Creek Conservation Authority, comments were provided under a separate cover. Ultimately, the comments, they didn't have any concerns other than that it was in a regulated area. They would need to be essentially flood-proof to existing flood-proof standards. And it would be subject to Kettle Creek Conservation Authority permitting. To get into the conditions themselves, the recommendation is that the application for consent is consistent with both the 2020 provincial policy statement and complies with the County of Elgin and municipality of Central Elgin official plans regarding consents for lot adjustments. As such, planning staff are of the opinion that the application is supportable from a planning perspective and recommends approval of the subject to the following conditions from the Land Division Committee in its decision from Elgin County. One, that a digital copy of the draft and final deposit reference plan be provided to the County of Elgin. Two, the severed land be merged in title with the abutting lot, municipally known as 437 West Edith Cavell Boulevard. And three, a solicitor undertaking whereby they inform the committee in writing that the lands are being conveyed to an abutting property owner, and thus a merger of title will take place. This merger shall include all interests held inclusive or mortgagees' interests. The additional one, that's the counties. I'll go on to the final one in a moment. Additionally, it is recommended that the following conditions from the municipality of Central Elgin be included as conditions for consent. One, the applicant solicitor demonstrates to the satisfaction of the municipality of Central Elgin that the lot addition will not impact existing services, i.e. water, sewer, hydro, rights of way, and or easements. Two, the severed land be merged in title with the abutting lot, municipally known as 437 West Edith Cavell Boulevard. 3, that subsection 3 or 5 of subsection 50 of the Planning Act, RSO 1990, as amended, shall apply to any subsequent conveyance or transaction involving the subject lands. For the solicitor or the applicant is to provide an undertaking whereby they inform the committee in writing that the lands are being conveyed to the abutting property owner, and thus a merger and title will take place, which merger shall include interest held inclusive or mortgagee's interest. And 5, the municipality of Central Elgin be provided with a copy of the reference plan. A new one was included as part of the decision on Monday, being that municipal condition 6, a drainage reassessment be done if necessary at the owner's expense.
Thank you, Kevin. Any comments from any of the members of committee?
Move the adoption of the recommendation. O'Grady.
Any other comments before I ask for a seconder? Does the agent have any comments?
Thank you, Mr. Chair, and through you to the committee. The only comment that I would make, if the members are wondering, I would note that the actual boundaries of the severed parcel don't exactly match the map that's shown on screen. The existing cottage will actually be within the boundaries. The cottage has been damaged and it's going to be sort of semi-reconstructed. I think they're trying to save what is existing there. From that image, it appears that the cottage that is on the severed part, the part to be severed, is sort of straddles another property boundary, but that's not in fact the case. It is actually it will be within the boundaries of the severed parcel as proposed.
Thank you very much. We have a mover.
Could I ask one more question in regards to that?
Yes.
Like that aerial photo, and then we have the overlay map, and I know we've not had this before, but as the applicant just mentioned, but if you look at that overlay map, it looks like half those cottages are cut in half by boundary. Is that the case, or is that just the technical aspect of the overlay map?
I'll ask Kevin to speak to that.
Thank you, Mr. Chair. This is, this area of Port Stanley, there are a lot of historical issues and concerns with buildings crossing property lines. Hence why in the previous application, staff has recommended legal opinions on statuses of properties based on registered plans and that in the past to deal with some of these previous situations. One of the comments is through the consultation process that was raised is why the cottage itself cannot be relocated to the portion of the property that was to the north. Throughout this entire area, there are quite a few different easements for rights of way access, parking, historically all over the parcels. So that this is why the lot adjustment was requested and included to go to the south, because the cottage itself couldn't physically go to the north because there are easements in place that are historically on title. Okay. And I will second Dennis's motion if you're waiting for a second.
Thank you very much. It's been moved by Dennis, seconded by Dube. I'll call the vote.
Mr. Aldred?
Yes.
Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Kasteren?
Yes.
Ms. Kennedy?
Yes.
Mr. Selden?
Yes.
Mr. Chairman?
Yes.
7-0, the motion is carried.
The decision.
Mr. Chair, and thank you to the members.
Mr. Chairman, if you want to have fun, the severance sketch on the preliminary application that was sent out to us shows all the legal lot lines, and it's impossible to understand that. So I wish staff the best of luck in trying to sort out that dog breakfast down there.
I just have one item to read here. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for the certification, or the consent will lapse and a new application will be required. Please leave identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. That's the last one, so nothing at the end.
Adjournment and stay on the line.
I'd like to call for an adjournment.
So moved.
Moved by Jack Van Castern.
A second.
John,
Was that Selden?
yes, Selden, sorry.
No problem. Mr. Aldred?
Mr. Aldred for the adjournment.
Thank you. Mr. Andrews?
Yes.
Mr. O'Grady?
Yes.
Mr. Van Castren?
Yes.
Ms. Kennedy?
Yes.
Mr. Selden?
Yes.
Mr. Chairman?
Yes.
7-0, the motion is carried.
Okay, we will now take a break